handling problem assets. But you can imagine how I felt looking around and thinking, if there are going to be layoffs, they're probably going to start with the young folks first. So I went to law school and have been working commercial transactions from the legal side ever since.
Awesome.
And much like Jay, I avoided leasing until I started my own practice and realized that clients with predictable recurrent needs are very special clients. And so leasing work is something that it's not the most attractive, but it provides some stability.
Great. Thanks, Catherine. Stuart Bourne, you there? Stuart? We'll come back to Stuart. Eric Nesbitt, welcome.
Thank you. Glad to be here. And I'm actually one of Jay Camlet's and LawBank's initial members. Maybe not one of the first members, but I think I was in that first year when you started LawBank. I got an office with you, and still am proud to be a member of the LawBank community. Although I no longer office there, I'm still a member of the community and don't utilize the office space as much as I would like. So I miss meeting many of you, camaraderie and so on, but I'm happy and proud to be a member of the community. So I am one of these strange guys that operates two businesses. I have a commercial real estate brokerage firm called the Nesbitt Commercial Group, and I've been operating that business now for about 8 or 9 years, and we focus on assisting owners and users of real estate, helping tenants find real estate to lease or investors that are looking to buy real estate. And I formed that when I left Jones Lang LaSalle about 10 years ago, and it's been a pretty good business until we hit this latest recession. And then I have my law offices of Eric L. Nesbitt PC, which is a firm focused pretty much on real estate issues, commercial real estate issues, residential real estate issues. So we do everything from title review to review of residential and commercial contracts. I do some work with Wells Fargo and US Bank and helping with some of their workout efforts or foreclosure pursuits. I don't actively litigation matters, but sometimes when my ego gets in the way and I write a nasty letter to opposing counsel on matters and I feel like they want to take it to court, I can't put my ego aside and I get involved and have had some success in the courtroom, although I don't tend to sleep that well when I do that. And I would say I spent, until this latest recession, I spent probably 30 to 40% of my time on the law practice and the balance of the time chasing commercial real estate brokerage transactions. And that has really shifted now because most of the commercial transactions I was working on, the brokerage transactions, most of those clients have hit the pause button. So I've gone full blown into being a full-time real estate attorney again for the most part. And it's nice to have the ability to shift from one business to the other and stay afloat during these hard times. So I look forward to meeting all of you, all the ones I haven't met, and glad you invited me to participate in the call, Jay.
All right. Greg Engstadt, you there?
Hey, Jay, can you hear me? This is Stuart.
Stuart, there you are. Hi, I can hear you.
Okay.
Why don't you?
My microphone was on. Sorry.
No problem. You want to talk about yourself?
Sure. My name is Stuart Bourne, and I've been working with small firms doing securities work, mostly real estate oriented securities work in forms of apartment syndications. And but right now I'm about 80-20 doing law and doing real estate development. My real estate development is backed by a prefab business that provides the the product that we put in our developments. Right now, we have 3 developments going, one in Morrison, one in Conifer, which is in a rezoning process. I'm doing the rezoning part myself. And the third one we just put under contract, 190 acres in downtown Grand Junction, surrounding the new hospital, which will be a large mixed-use development backed by private equity. So I'm always in the market for financial resources with private equity, who disappeared for a couple of months, but are starting to come back.
Great. Great. Thanks. Thanks, Stuart. Greg Angstadt, sorry, are you there?
I'm here, but is the sound coming through okay?
Yeah, sounds good.
All right, so yeah, I'm Greg Angstadt. I'm one of the ancillary practice area attorneys. My specialty is in environmental law, and the folks at LawBank have been nice to bring me in on some projects that needed review of environmental site assessments, phase 1, phase 2 assessments for the transaction. We've also do a fair amount of work with negotiating environmental cleanups. And the other area where I specialize is in industrial operations or manufacturing operations that might have permitting requirements, either air emissions or water discharges. And sometimes in the world of landlord tenant commercial real estate, you'll find a landlord might have an industrial tenant and they want to set up an environmental indemnity agreement to protect them from the tenant's operations. So I've worked on some of those projects. I've been with LawBank, maybe since 2015. So it's been a good number of years.
And I can attest, Greg has got to be one of the smartest guys I've ever talked to. We pitched a client the other night in Hong Kong. It was a Portuguese company with a Hong Kong representative who is looking to get licensed in America for certain of their products. And I pulled Greg on that call, and it was an amazing call. And Greg was prepared to the teeth on this thing, and we'll see soon whether that becomes a client or not. But that's how we utilize the network here, bringing all of our expertise together to try to pitch one client, just like a law firm would. So I was really stoked after that call, Craig. So thank you.
That'd be a fantastic project. Okay.
Yeah.
Forward.
All right, Carolyn Topelson. Can you talk, or are the babies in the background? Carolyn, you there? Well, we'll come back to her. Rob Fisher, you there?
I'm here. Let me get this turned on. Sorry. Hi, everybody. Rob Fisher. My practice is about, I'd say 70% commercial, 30% residential, all real estate transactional work. I love leasing. I'm a low-key guy, and leasing kind of fits with my personality, but I also do a lot of other transactional work, buying and selling, easements, entitlement work, also some telecom agreements. As far as working with my peers over at LawBank, love doing that, do a lot of work with Carolyn, do a lot of work with Tony King, partnered with several other attorneys over at LawBank. With what's going on now, getting lots of calls from people, both on the tenant and landlord side, trying to figure out how to ride this thing out. I think everybody's suffering a little bit, just trying to figure out what's going to happen this summer, how long this is going to last. So is the remedy going to be kind of a short-term remedy, or do we need to anticipate kind of a longer term? So everybody's wrestling with that right now, and trying to basically stay on top of everything coming through the state and from the federal government and from DORA, as far as changes of regulations and being able to advise clients on those changes. So yeah, so that's what my practice has been. It had been a great year. Things are definitely off. Trying to figure out how to survive this. How do I broaden the practice? How do I tap into maybe the estate planning people or other kinds of real estate opportunities that might be a little bit less dependent on the overall economy. So look forward to meeting all of you that I haven't met so far. I've been at LawBank for a while, Carolyn, and I've been there I think since 2015. It's been a great experience for us. Love it there, wish everybody best of luck getting through this time.
Thanks, Rob. Adam DeVoe, you there?
I'm here. Can you hear me?
All right, there you are. Yep.
Great. I just want to first say I'm so impressed that everybody's actually in work clothes this morning. I'm still in work at home mode in a t-shirt.
Okay.
So I am brand new to LawBank. With my impeccable timing, I started my solo practice in February of this year, just in time to watch the economy slow down immediately. But luckily things have been going okay so far. I am an environmental lawyer and a water lawyer. Sort of relevant to this group, I spent 12 years at Brownstein and then a few years after that at Rothgerber. I've done environmental real estate development work from, small developers rehabilitating gas stations to Prudential Real Estate building $500 million apartment complexes on brownfield sites. And then on the water side, spent many years as one of the lead litigators for Aurora Water. And so, and for Idaho Power Company, have worked on water issues throughout the Western United States. So if your clients have water needs, water issues, I do a lot of that kind of work. So look forward to meeting everybody in person when we get back to normal, and if we get back to normal. But thanks, Jay, for setting up the call.
Yeah, thank you. Thank you. Adrian Fisher, are you there? Adrian?
Can you hear me?
Yeah, there you are.
Hey, hi. I'm Adrian Fisher. I founded Basecamp Legal and started with LawBank 4 years ago. It's hard to believe. Jay knows this, I'm kind of bouncing all over the world normally. It's the first time I've been grounded. So I look forward to meeting all of you once things get a little bit more back to normal as well. Normally, I've done the last 4 years have been focused mainly on corporate transactions, mainly in the small business and kind of startup space, doing everything from fundraising to trademarks to just helping draft operating agreements. And then last year, I was fortunate enough to meet a real estate developer that took a chance on bringing me on as his main outside counsel and have really shifted into more real estate, even though my practice did touch on some commercial leasing. And I kind of grew up in real estate. My mom was a realtor when I was a kid. I started out answering her phone calls, and then I worked in real estate offices all the way through college. So it's been a very interesting kind of addition to the practice, and I look forward to just learning as much as possible. I've been fortunate enough to meet some mentors at LawBank, and then I see Barb's on the call. She's been a great resource as well. So
let's meet Barb. Hi, Barb. Are you here?
I am. Hang on. Can you guys hear me?
We can hear you. We just can't see you.
Okay, cool.
If ever makes you happy.
All right. So I've been practicing real estate for about 30 years. Basically, anything in real estate is what I've done, except for created securities from real estate. And I have had solo practice on and off for about the last 20 years, depending on whether we're in an economic crisis or not. So I just recently rebooted my solo practice about 3 years ago. And I am also chairwoman of Colorado Women-Owned Law Firms. And I'm very excited about your series of presentations and look forward to a good partnership.
Absolutely, Barb. Thank you so much. And for anybody on this call who doesn't know Wolf, will you talk a little bit about what Wolf does, Barb?
Sure. Wolf is a member organization of the Sutherland Small Firm, and our members are all women who own their own law firms. Law firms are at least 50% female owned. And we've been very fortunate because unlike some solo and small firm groups that are splintered by practice, the thing that holds us together is the common experiences that we all have.
Great. It sounds like a great organization, and we're really proud to be aligned with you as well. All right, Ashley Capel, are you there?
Yeah, I'm here.
Hi, Ashley.
Can you hear me?
Yeah, we can hear you.
Okay, great. Hi, everyone. I'm Ashley Capel. I've known Jay for a long time, since I used to work for him at Lathrop & Gage. He kind of gave me my start, and I'm thankful for that. And I've been at LawBank for about a year now. Gotten to work with several attorneys over here, Rayhan Hassan and Stuart most recently, and Jay as well. I practice transactional real estate, doing leasing and purchase and sale and loan documentation. So happy to, help with. And I've also worked with Greg. He's been great on environmental stuff. So really appreciate that, Greg. And just look forward to getting to know all you more. Thanks so much.
Thanks. Brad O'Brien, you around?
I'm here. So I've been at LawBank since 2016. I do both transactional work and litigation involving real estate. In previous parts of my career, I was 100% litigation or 100% real estate with a couple of downtown law firms. So I'm loving life now, keeping really busy, kind of following the Willis Carpenter model. When I took his class, he said a good real estate practitioner ought to be able to do both sides. And so I do. And it's kind of runs with the economy. I was doing a ton of foreclosures and evictions and whatnot from 2007 to 9. And then it was a lot of transactional work in between, but now I'm seeing it come back. The foreclosures and evictions and workouts and short sales and those kind of things.
Great. Thanks for that. All right. Tracy Herman, you still with us? Tracy? All right. Maybe not. Let's see. Is Carolyn back with us? Okay. All right. Who's left? I think that unless Tracy's available or Carolyn will kind of, unless I missed anybody, I think I got everybody. So again, this is pretty casual. We don't really have an agenda for today other than to, one, again, look around this group and see what kind of talent we have amongst us. And then really, if there are any issues that anyone is particularly grappling with, either in their practice or their clients' issues, please speak up. There are a couple folks. Eric Nesbitt has been speaking a lot. I believe, Eric, on force majeure clauses or general common law. I was wondering if maybe you could start there, talking a little bit about those. Or I don't want to throw you under the bus here if that isn't correct, but I think some of your webinars have been focused on force majeure provisions and and general common law applicable to leases?
Yeah, the first one I did a few weeks ago was just on force majeure because I was receiving calls from both residential tenants and commercial tenants as to whether they use the COVID crisis or the pandemic to get out of paying the rent or their monetary obligations under their lease. And I did a little bit of research on it. In my 30 years of practicing law, I can't remember another time when force majeure language has really come up and something that's invoked. But turns out there are two issues that really have to be addressed when looking at force majeure. First, the specific language in the force majeure clause really has what the issue is. So after some type of language in the lease that says government shutdowns or pandemics or any type of pandemics similar to what we're facing, it's going to be tough for a tenant to rely on. But more important, a lot of the force majeure language I've looked at specifically carves out the right of the tenant to stop paying rent when one of these events occurred. So even if the language in there says something about a pandemic or a government shutdown, it's not going to relieve the ability of the tenant to pay rent. So the long and the short of it is I found that it wasn't a very useful clause in most instances for the tenant to utilize or rely upon. And I advise many of my clients to simply have a discussion with the landlord to see what they might be work with them in terms of a deferment of rent or an abatement. Abatements of more of a stretch because landlords don't want to do that if they can avoid it. But deferment of rent, I think, is a better approach. And actually, in my personal situation now, where I have a chiropractor tenant in one of my units, and I was surprised to get their rent check in April, but they called me a week after I got the rent check and said, I'm not going to be able to pay rent in May, and will you work with me? So I am going to write them back today, actually, and let them know that I'm going to relieve them from the obligation of paying their rent in May because they just haven't been able to make any money in April due to being closed. And I'm going to extend the term of their lease 1 month and capture that rent down the road at a 3-year lease, and I'll just make it a 37 or 38-month lease and try to capture that money at the end of the term. So try to be flexible. Fortunately, I've been able to get some of the PPP money that's come down, as well as the economic disaster injury money. So that's specifically used to relieve my tenant from paying rent in May. So I figured that's the right thing to do.
Do you, so I've had two situations where, well, two scenarios. One is an office tenant user, and one is a retail tenant user. Most of my office, and I don't know if anybody has any other experience with this, most of my office tenants have been given rent deferment, where they are given up 1 to 3 months of deferring their base rent. They still have to pay their additional rent or some portion of their additional rent during that time, their triple net charges. And then that deferred rent is then paid over a period of 3 months to 6 months, even a year. One got a year deferral, or so that they pay those missed months. They pay the rent that they would have paid in those 3 months. They got deferred over a course of 3 to 12 months. Mostly, all of them have been interest free. The landlords haven't tried to charge interest on those. And then on the retail side, I was just talking to a landlord today who has a Red Lobster restaurant in Southern California that basically just stopped paying rent. Said, you know, we don't know what's going to happen to us, but we can't afford to pay your rent right now. He's been hearing that retail landlords have actually been giving rent forgiveness for several months, even up to 6 months. And I'm just wondering, and then no deferral, no repayment of those. I'm just wondering if anybody has any experience on the retail or office side that is any different, or what you've been seeing.
I can speak to the office side. I have a large office tenant client I represent with about 30,000 square feet of space that they occupy in the tech center. And they asked me to go to the landlord and negotiate renovations for 3 months. So I wrote a letter seeking rent abatement as well as to surrender or give back some of their space in the building. And I just heard from the Tom Liss represents the landlord with Moya White. I just heard from him yesterday. And he was nice about it, but he said, we're not going to do any renovation. We're going to give you, we would be open to rent deferment, and we would do 90 days or 3 months. My client wants to be relieved of the obligation to pay base rent for June, July, and August of this year. They would pay the operating expenses during that period of time. And we really wanted to have that base rent obligation go away or be abated. The landlord has come back and said, we won't abate it, but we'll defer that rent until January of 2021.
Eric, question?
As a fallback now, discussing with my client really would like to see, given that we're not going to be able to negotiate the abatement, if we could pay that rent back by December of 2021, that would be probably our fallback position, as well as give some of the space back. We initially wanted to give about 7,000 square feet back. Now we're probably only going to request 2,000 to 3,000 square feet back, plus have that rent deferred to later in the year. And then hopefully they don't come back, the landlord doesn't require us to give any further security in the form of personal guarantees or a more hefty security deposit.
Eric, are landlords coming back and basically saying, can I make an offer to us? I have a landlord client that basically, we got a request for assistance, and my first contact back to the tenant is going to be no. And so I think my client's position is basically they don't want to negotiate against themselves. Is that what you're saying too? Or are you going back? Are you seeing landlords going to tenants saying this is what we're willing to do? Or are tenants typically going, hey, landlord, we need you to provide X, Y, Z to us?
What I've seen thus far is the landlords request relief from the tenants request relief from the landlords. And the landlord in most instances will say, provide us with your financials, your why the pandemic is hurting your business and what you forecast over the next year or two. That's at least in this latest case for the client I'm representing. And in addition to that, provide us with what relief that you're seeking. So allow the tenant to make the first request, and that starts the negotiation. But in most cases, the landlord wants to see financials and see where the financial pain is before they entertain a discussion about rent relief, abatement, or deferral.
We're a landlord up in northern Colorado. We have a property in Fort Collins that's industrial. And one of the tenants in there is in robotics with the U.S. government, but also private contractors. And we knew that they had small margins at this time of year. So we were proactive in approaching them to say, how are things going? Do you need some relief at this point? And then we kind of ran the proposal in terms of what made sense to us. So it was nice to have that level of control. But the way we ended up structuring ours is we gave them a 50% reduction in their rental base rent for up to a period of 6 months. But it was tied to whether there was a stay-at-home or municipal order that impacted their business operations at the location. So to the extent that 2 months from now, any orders for from the governor or for that municipal area are lifted, they then resume the rent payments. So it wasn't really a fixed duration, but not to exceed 6 months. But Jay, it doesn't surprise me regarding retail that's the tack they're taking. I think the only person that's really making money hand over fist right now is Amazon. So to go to retailers and malls and say, okay, you don't have to pay rent now, but you're gonna have to pay double rent when you come back, I think that's probably a hard pill to swallow.
So
Yeah.
I'm gonna try again. Can anybody hear me? This is Carolyn.
Yes. There you
Oh,
are.
yay.
Hi, Carolyn.
Hi, I fixed my microphone, so that's good. Well, just very quickly, I'm Carolyn. I'm sorry I could not introduce myself earlier. I do litigation, but I also do some commercial transactions, specifically helping with leasing and things of that nature as well. I do quite a bit of residential, but I do a lot more in the commercial world, which is much more fun for me. But what I was going to say is that what I've been seeing is that whether the landlord or tenant starts the conversation in the commercial world actually depends on the relationship between the parties. And so what I've seen in one of my clients, and actually this is directly my uncle who owns a whole bunch of buildings, he has a good relationship with all his tenants, and one of them said, hey, we've been shut down because of this stay-at-home order. And in that case, my uncle as the landlord made an offer of what sort of the abatement would look like. And in that case, they're giving a 3-month, 50% off minimum rent, and then just waiving the other 50% because they're brand new into this lease and only a year into a 10-year lease. So they felt that that was worth it. But I have another client who has he's more of a property manager, and he's saying that it really depends on the strip malls. It seems like what they've been doing is actually talking to each individual business based on whether or not they've been shut down and seeing what the tenant sort of sees as their own business model, but not necessarily asking for financials. And I'm sort of seeing the same thing there, that they're saying kind of what Eric was saying, that they'll say, okay, maybe you've got a deferment of X amount now, but we'll put it on the back end, maybe starting in January or February of next year, and you'll have to pay whatever's outstanding over the next year. So you'll pay it not all immediately, but if you got a deferment for 3 months, those 3 months would be then placed over a 12-month period paid back.
And Carolyn, I apologize, I omitted that. This up to 6 months, 50% abatement that we're offering that tenant, we're having it amortized over, I think, the next 12-month period as well.
Jordan, are you seeking to have, are you going to charge interest on that amount that's being amortized?
No, I mean, similar to what Carolyn said, the investor that's based up there is also the on-site property manager, and he has a good relationship with the tenant. So, you know, in the interest of keeping them afloat right now and not forcing our tenant out the door, we're trying to limit the expenses and not be too greedy. We're able to make our debt service payment from the other tenant in the building, so we're covered in terms of a DSCR perspective. So it does make it a little bit easier on us to not charge interest.
So on the flip side of that, is anybody having any luck with their lenders, with their clients' lenders on deferrals or abatements, or just general people are being nice to each other?
So I'm actually in the middle of renegotiating with several lenders, and it remains to be seen how nice they will be. I think liquidity is obviously an issue right now, and I think it's just going to depend, and I can let you know how it goes, but I'm renegotiating on behalf of my client with several lenders.
So most of the lenders, I'm sorry, go ahead, whoever is going to speak.
Jay, it's Catherine, and I represent a private lender, and there is some leniency, but again, it's a private lender, not a larger bank.
Most of the lenders I've been dealing with are willing to give they're just kind of off the bat saying 90 days of deferral, and basically it's a deferral of payment. So again, to what Eric said earlier, I think they're just adding that on to the term, the 3 months. So it's not a waiver, it's a deferral to the extent that you don't have to pay it back quicker. It's just saying we're going to extend the term of the loan out 3 months. We're going to give you 3 months of grace period, and then your loan will extend for those 3 months of missed payments.
So Jay, I've heard something a little bit similar, that they're deferring payments for certain periods, certain lenders are, but that the interest that accrues during the deferral period, they expect due and payable in full the first month that they're required to make their next principal and interest payment. So, I think that's a word of caution for all the attorneys here, that as you're working with your client and a lender, make sure there's no pitfall like that where suddenly they're facing, their first principal payments as we come out of this, along with 4 to 6 months of interest paid all at once.
Do you guys see, because I really haven't been dealing with this, but banks sort of following the model of what the CARES Act is saying with respect to that's where the 90 days come from and things like that, even though this is not necessarily residential?
No, the banks I've dealt with did that even before the CARES Act came out. The one thing nobody's really talking about, which is a good thing for all of us, is that the banks after the recession are in a lot better financial position than they were back in 2008, 9, 10, 11. So nobody's really talking about, do we have to bail out the banks now, which is a good thing, because I think the minute we start talking about, or we're going to have to bail out the banks, we're in much deeper trouble. So the good news, I think, is that the banks are much more solid financially. So they're able to absorb and deal with these things a lot better. This is definitely affecting Main Street, but at the same time, a lot of my clients that deal with the commercial mortgage-backed securities market are not finding any solace in new loans, for sure. I haven't heard anything about the servicers of the existing loans, of whether they're giving some relief. But the lending market, speaking of liquidity, Catherine, is really drying up for the bigger commercial deals. Now, this may room for general community banks, which I think are still pretty active, and they actually may have a better opportunity to start being a more first lender of choice. The risk of that is very few are offering non-recourse debt. So the non-recourse debt isn't there, and the recourse debt may be there, but you've got a lot of equity.
And of course, it's going to be on smaller dollar loans.
Right.
So.
Yeah. I mean, even a buddy of mine was going to buy a 7-Eleven, just a triple net 7-Eleven deal, and the best he could get was 5-year money. So, who knows what's going to be in 5 years, what the rates are going to be. He's looking for 10-year money. And so he doesn't think he can get a 7-Eleven deal done.
Hey, Jay.
Or anyone else.
Jay, this is Stuart.
Hi, Stuart. Yeah.
On a tangent but related issue, the Colorado legislature in section 38381066 offered some protection on deficiency judgments. If your client is in that situation, you should look at the protection under that statute, and what the statute requires to maintain your deficiency judgment is that the lender bid in a number that is reasonably close to the value, and if they don't, there's remedies that reduce the deficiency judgment. If they don't bid in the right amount, at the time. Now, it's important to remember in this deficiency judgment protection, it only applies to the borrower. So, well, a lot of times lawyers will say, you'll blow off the deficiency hearing and say, we'll fight about it when we're dealing with the guarantors, but the guarantors are not given this protection. But the way they get the protection is if the deficiency judgment is lower because they litigated the issue of the appropriateness of the bid of the lender.
Say, I lost you there on that part. So if they do litigate the deficiency, it's
if the borrower litigates the borrower has to litigate the appropriateness of the bid by the lender at on the deficiency. That gives the guarantors rights if they were successful in reducing the amount under the guarantee, depending on the guarantee language. So it's important to actually defend a deficiency hearing if there is one.
great. Perfect. Thank you. I was not aware of that. So I think one of the things that we as the real estate lawyers on the call have to be very mindful of these next few months is to get boned up on these type of issues if you're representing debtors and creditors, and to either connect with somebody who has this expertise, and in particular bankruptcy lawyers. This is a time when our network really should focus on including bankruptcy lawyers into the fold of our close friends and advisors, because when we're giving advice to whether it's a landlord whose Red Lobster's gone out and Red Lobster may file bankruptcy, or whether it's a tenant like a healthcare a health club as a tenant may file bankruptcy, we need to be proficient, or at least have somebody with the knowledge of this. So please add creditors' remedies, debtors' rights, creditors' remedies, and bankruptcy lawyers to your list of friends. In this time, I think it's going to be critical to know some of the nuances involved in those areas of practice. So I will promise to try to bring in more bankruptcy lawyers into LawBank, and if I can't get them to come in, I'll still have them as resources for our folks, because it's really, in order to give your clients really good advice, you need to understand that potential, whether it's for them or for their tenants or for the landlords, what's going to happen, and how you can negotiate. The best workout lawyers that I've ever worked with were those that really understood the bankruptcy laws, because they knew how far they could push the other side, knowing what protections they're going to have if they fall into bankruptcy. So start adding your Christmas list, folks.
Hey Jay, can I underscore that point? That's really, really important. And in the letter that I did on behalf of my office tenant seeking to get some type of rent relief, I lightly threatened potentially filing Chapter 11, and not knowing much about Chapter 11, I contacted Nathaniel Thompson, who used to be a law banker, just to have him review my letter and make sure I was citing the right provisions of the bankruptcy code and so on. And one of the points he made was be careful with the threat of bankruptcy, because in some lease agreements, if you let the landlord know that you just can't pay your obligations, that letter in itself could create a default. So he made me aware of that. So my language in my letter wasn't to the effect where it crossed the line and could be construed as a default. But at the same time, it had enough meat on the bone, so to speak, to let the landlord, let the landlord's attorney know that we might have to go this route if they're not willing to work with us. So I couldn't agree with you more there. I don't know if we have other attorneys in the office in the LawBank, our community, that do bankruptcy, but I got to know Nate pretty well and like working with him for what it's worth.
Well, one of the things, this is Stuart jumping in, in tenants, I haven't found bankruptcy to be all that helpful because the pre-petition arrearages have to be paid in the 11 plan. And so you really don't wipe out any of those pre-petition rent arrearages. And then I think it's 60 or 90 days after you file, you have to assume or reject the lease. And, the only way you can discharge rent theoretically is if you reject the lease. There really isn't any, there's short-term relief, but there isn't any relief from the payments if you want to stay in business.
Well, in my case, my specific case, it might not be a bad idea for my client to reject the lease, given they've got 5 or 6 more years left on it, surplus space. So the rejection and the potential to relocate to another office space wouldn't be that bad of a scenario. But I take your point, Stuart. I understand what you're saying.
So I have a question, if that's okay.
Yeah.
With respect to all of this, what obligation or duty do you guys believe that landlords and tenants have to disclose if they've received, if they're a small business, a PPP loan or some sort of EDL loan to help offset the cost of rent, which is part of what these loans are for, if they're claiming, on the one hand, and also having people who aren't necessarily affected by COVID and the stay-at-home orders, and having, for example, the truth is, there's a lot of companies that, while they're not physically using their spaces, are still fully operational because they can all work from home. So what obligation does a landlord have in those situations to give some sort of rent modification or things of that nature?
I don't think there's any duty. I don't think there's any duty to from the for the tenant to tell the landlord that he's gotten money from anywhere.
One of the things I just did a lease amendment for a tenant. The landlord had presented the deferral agreement. One of the conditions on there was that they had not received the PP. They have to represent and warrant that they had not received assistance. And it wasn't that they didn't have like a line of credit. It was government assistance in the form of a PPP or SPDIL, whatever the other one is. So that we had to represent that we did not, or that we didn't qualify for that. And that, I think Jordan said it earlier, what he did was say, to the extent you do.
Hello?
You leaves them. So there are certain ways, again, of putting reps and warranties and conditions subsequent that can help put the landlord back into a quicker position, knowing that the tenant has been able to seek some government assistance.
So Jay, what's the logic, I guess, from the landlord perspective, that to the extent they are receiving government funds that could be allocable to rent payments, that they shouldn't be receiving relief? Is that just it on its face?
Yeah, honestly, you can only, I think you have to spend, 75% of the PPP money
80
on salary? What's
Yep.
that?
I thought it's 80, but I don't know. I'm there.
There is
Go
one
ahead.
approach. There is one approach, and that is what a medical office tenant who is willing to negotiate some sort of relief, but at the same time, they want to be reimbursed for their attorney's costs. So if a tenant doesn't really need the relief and they're balancing that with, gee, I have to pay attorney's fees now, that may keep them a little bit more honest about it.
Barb,
Yeah.
you cut out there a little bit. Can you
Oh,
repeat
sorry.
that?
Yeah, medical office tenant is, or landlord is willing to give tenants relief, but part of that is that they are reimbursed for their attorney's fees. So if the tenant is weighing, well, do I really need this because I'm not really struggling that much? Or is it worthwhile for me to pay attorney's fees? So, and I think this also kind of brings to the forefront for tenants that this is not a costless operation for landlords, that there are costs of the transaction that somebody has to pay for.
Good.
So I'm looking at a document on the Treasury's website, and it says not more than 25% essentially can be used for non-payroll costs. So my approach has been, even if they are receiving PPP, the amount that can be used towards
Fair
lease
enough.
payments
Good.
is minimal.
Good point.
And when working on any sort of lease amendment or modification, if there isn't a financial statement disclosure requirement already, that's a good time to add one.
Yeah. Any other thoughts on this? Okay. Any other conversation that any questions people have that they want, the burning questions for themselves or their clients? I know we had this scheduled till 11:30, and we're happy to go that way. But if you guys, if you're lucky enough to have some work to get back to, we don't want to take you away from it. If there's anything, again, any help that we can provide for you, please let us know.
So,
and, yeah, go ahead, Carol.
Sorry, Jay, to interrupt. So one thing that I do a lot of residential as well. And so prior to my nanny coming back, all I could do was think about law. So not actually do it. So I was thinking a lot about the residential world and all the landlords who are not getting paid by their tenants who lost their jobs, and sort of what can happen and what can be done. And I just wanted to let everyone know, I found out yesterday and today, actually at noon, there's a little CLE on this. There's a group that put together something called COVID-19 Eviction Defense. And I know they're always looking for volunteers to basically help tenants through this situation and advise, basically to some degree, landlords as to what to do in this case, especially in light of all the federal and local regulations that have been put in place to stop residential evictions. And every county is a little bit different. But if it's something you're interested in getting involved with or wanting to help a little bit on your spare time and maybe even advise, you can check out their website. I think it's COVID-19 Eviction Defense, Colorado, I believe it's called. And or, I can give you the name of the person who's doing this. I think it's really important to recognize that this is going to change the landscape of commercial and residential evictions, because as some of these laws are being put in place to stop residential evictions, they have the undue, I guess, effect of also implicating commercial evictions. And what I mean is, like, for example, Denver put together a statement saying that no sheriff move out will occur unless it's for safe and health reasons prior to May 11th. Well, during that time, that also means that any commercial tenant that wanted to be evicted wouldn't be able to be evicted because they've removed all sheriffs from eviction. So while the intent was for residential, it's actually affecting commercial as well. And I think that as we're advising our clients, especially landlords, about, what can you do? How can you work with your tenants? And you're not willing to work with your tenant, also understand that you may have some trouble getting the eviction done.
Well, so one thing I want to add to that, Carolyn, I'm overseeing the office leasing for a new development downtown. that's coming online January of next year. And it's amazing what this has done to the commercial brokerage community in terms of prospects and getting deals done. We were about 85% committed between leases and RFPs, and we are now down to about 15%. So to the extent that landlords want to play hardball and force these tenants out, they need to be cautioned that they may be hard pressed to find someone that's interested in space at this point.
And I agree. I mean, I actually had a conversation with a bank who was trying to call a client's loan because their debt to income ratio was 1 to 28 instead of 1 to 30. And I said to the bank, you're kidding me. They're actually paying you. They haven't asked for a deferment, and you want to possibly call a loan for what purpose exactly? Like, you're going to try to foreclose at a time when you can't even do foreclosures right now because the governor, at least through the end of the month, which I guess is tomorrow, has stopped them. I mean, this is the problem. And then what is the bank going to do with these properties that are now maybe vacant and no longer making money because they foreclosed on them, right? The tenants might go away.
Right.
That may be true, but if the asset is if the loan is classified by a regulator, you know, the loan, even if it's performing, it goes off the books as a loss, and it can be brought back if it gets paid off. So the bank may not be in a position to want to carry a classified loan because it to them on their books, it eats into their capital and wipes out a significant, the asset is of no value to them because it's treated as a loss by the regulators. That's why we'll be doing it.
Didn't they, to a degree, relax restrictions or requirements on reserve balances relative to riskier debt placements during this time period, specifically for that reason?
You know, the federal regulatory scheme is schizophrenic on these kinds of issues. The Federal Reserve can do stuff that is, that seems flexible, but ultimately the decision comes down to the regulators in the FDIC, who are deathly afraid that there isn't enough money in the fund to support any bailouts. So they want to classify anything that's closed. And frankly, the way banks work, there are two sets of regulators that go in, one from the one through the Office of the Control of the Currency, which is controlled by the Federal Reserve, and the other one by the FDIC. So you may have come out with a great examination from the OCC, but get creamed by the FDIC because their motivation is completely different at this time.
I appreciate the clarification. That's very helpful. Thank you.
Hey, Carolyn,
All right.
Oh, never mind.
Go ahead. No, please go ahead.
Well, I was just gonna say, Carolyn, if your client still has income and the asset is properly collateralized, would it be possible for your client to modify the loan to more favorable, get a lower debt service coverage ratio so that they can they can be in compliance and remain in compliance moving forward? So they're happy, the bank's happy.
That's what we're trying to do. Apparently, the big issue for the bank is that the loan required that the owners don't pay themselves more than whatever amount that was, and they went over by $50,000, and it clearly says that the bank can just write a note saying fine, whatever, and they're just really upset by this for no apparent reason. Honestly, it's unclear to us from our conversation with the bank what is upsetting them so much when this is a highly performing loan, and they've asked for a variance also on the debt because it's not it's a huge differentiation. It's instead of 1 to 30, it's 1 to 29. You're not talking about a huge differentiation. Yeah.
I had this situation with a client, an apartment owner client, and U.S. Bank was pushing on the debt service coverage ratio when a couple of tenants left, kind of en masse. So the rents went down, and I spent 3 days reading and reading and reading the loan documents, and somewhere buried in the loan agreement was a minor default extension period of the cure right. So we had 90 additional days to get it back into compliance because, if we did certain things, and it was buried in the loan agreement. So maybe there's something there in the buried in your loan agreement.
Honestly, in our case, my client is talking to another bank who's offered to give them more money at a better rate. So honestly, that it's one of these situations where the client's like, we've worked with you guys for like 30 years. What is going on? Like, why? And also COVID right now, really? This is when you're bringing it up? So bizarre.
Right now, there are a ton of banks that, so when the regulators feel like there's something that's not going well in the thing, what they'll do is they'll give a letter advisory to the bank, and if they're working on under a letter advisory, they're kind of under double secret probation, and so and at one point there were as many as 50-60% having some kind of letter advisory from the FDIC, which made them a little skittish on technical defaults in their portfolio.
Thank you.
Okay. Any other burning questions? Well, with that, I want to say thank you to all of you. This was very enlightening. This was amazing. I'm very pleased. I still would rather have y'all sitting around a table where we're all eating lunch, because I miss lunches with my friends. And Catherine, did you want to say something?
Yes, I have one burning question, which is, which office does everyone work out of?
We have a mixture. We have some folks at Uptown, and then most of the people on this call are probably Colorado Boulevard.
Okay.
Say Zach, Amy Brima, and Gangstat are all at Uptown. So we have about 60 some people at Colorado Boulevard and 30 some people at our Uptown office. So, but you get access to all of them. So, love to invite you to join us at some point. And everybody, thank you so much. Stay healthy, and we hope to spend time together. We'll have to do this again. This was very great. And but hopefully next time we're together. So take care, everyone. Thank you all.
Thank you.